Can you hear me?
Yeah.
Can you hear if I'm talking like this?
Yeah,
Good?
now they can.
Okay. So it's fitting that we're having technological issues because we're in Pennsylvania in 1795. So this is going to be a fun, but in many ways serious way to kind of bookend all of the ideas that the panelists have talked about and kind of to bring it home in a concrete sense because these issues were litigated. They had consequences for people's lives and their rights. And so this is going to be a mock argument that is based loosely on a real case that was argued in 1795 in Pennsylvania. We've taken some liberty with the facts, fittingly, and it will be before the Pennsylvania Supreme Court, which has chosen for some reason that's been lost to time to sit as a three-justice panel. But that's the way that they, we heard that that's what they did. So they're going to hear the case. I'm going to begin by giving you a little bit of background on that case that it's based on, so that as the argument is going on, you can have a better idea of what's at issue. And then I'm going to introduce the judges and our advocates, and then I will hand it off. So to start with, the case that it's based on is called Van Horn's Lessee versus Dorrance. And it's a very interesting episode in history. It grew out of one of the longest running territorial disputes in American history, and it was a Connecticut-Pennsylvania conflict over the Wyoming Valley, which is in modern-day Luzerne County. And the dispute originated in overlapping land claims. There was a royal charter given to Pennsylvanians by the king. There was a royal charter given to people from Connecticut by the king. And unfortunately, it happened to be the same land. So this led to a bunch of problems. It resulted in bloodshed not once, not twice, but 3 times in something called the Pennamite-Yankee Wars. The Pennamites were the Pennsylvanians, the Yankees were the people from Connecticut, and it was bloody and brutal, and it was literally a bunch of colonists fighting over the same land that they both had pretty plausible claims to owning. And so there's an attempt to resolve this first through something called the Trenton Decree in 1782. It's under the Articles of Confederation. Congress convened the only Article 9 interstate dispute court ever to reach a judgment in this case. So that's how important this was. And after 41 days of proceeding, 5 judges unanimously ruled that Pennsylvania had sovereignty over the land. But critically, that doesn't resolve what happens to all of the different property claims. It says that Pennsylvania is in control of what happens to the land, but not necessarily what you do with the fact that there are still people from Connecticut claiming to own land there and people from Pennsylvania attempting to live there. So what Pennsylvania does to try to resolve this chaos, and I say attempt because, as you can see, there's litigation, so clearly something didn't work out. They enact something called the Confirming Act of 1787. And what the Confirming Act does is it attempts to harmonize these issues and make it go away. And the way that they thought they would do that is for Pennsylvanians who had a claim to this area in the Wyoming Valley, they would shuffle them to a different part of Pennsylvania and give them land there that was equal to the land they had in the Wyoming Valley. And the people from Connecticut who had claims in the Wyoming Valley, they would get to have their pieces of land there. Now, not everybody was happy with that arrangement. You can imagine being someone from Pennsylvania said, I thought that we had the better claim, and you're getting kicked out to another area of the state. And the problem to those people was that the Confirming Act took vested property from them and gave it to Connecticut settlers without a process that they were in favor of. And to understand why that's a strange issue to litigate in Pennsylvania at the time, you have to understand a little bit about Pennsylvania's unique constitution, which I did not plan this. None of us planned this. The 1776 Pennsylvania Constitution has come up a lot today in the different panels. And there's been a lot of commentary on how it's unusual or the kind of novel things that it did. And so I'm going to tell you a little bit more about that, which you'll kind of see expanded in the argument. So Pennsylvania's 1776 Constitution was one of the most radical Revolutionary era state constitutions. It concentrated power essentially in a single institution, the People's Elected Assembly. There was no Senate. There was no governor with a veto power. Judges served 7-year terms and could be removed for misbehavior. And the 1776 Constitution opened with a Declaration of Rights consisting of 16 articles. You've heard a little bit about those Declarations of Rights today. It declares things like the natural, inherent, and inalienable rights to own property, a jury trial, freedom of speech, of press, and religious liberty. One of the wrinkles in this is that Section 47 of the 1776 Constitution established something called the Council of Censors. And it was a body of elected citizens chosen every 7 years, and their duty was to meet periodically and inquire whether the Constitution had been violated, and if so, what to do about it. And the Council of Censors could recommend repeal of laws, and they could, by a 2/3 vote, call a convention to amend the Constitution. The Council of Censors met one time in 1783 to 84, and it was, by all accounts, a spectacular failure. There were two different factions warring over whether there had been constitutional violations, and if so, what to do about them. Gordon Wood would later write that the council's creator had pulled a monster out of Roman history. But there are some more recent revisionist accounts that frame the Council of Censors as an attempt, a genuine attempt, if not imperfect, to begin to enforce a novel written constitution. And so that brings us to the parties and claims in this case, and this is how Van Horn's lessee versus Dorrance actually rose. Cornelius Van Horn holds title to a little over 190 acres under one of these original patents in this contested area in the Wyoming Valley. He owns this property, but the defendant, John Dorrance, lives on that property as actual possession, and he's a Connecticut settler. And so he benefited from the confirming acts in that it would allow him to stay, and someone like Van Horn would need to move to a different part of the state. So Van Horn argues that he has valid title. He moves to eject Dorrance from the property. And Dorrance's defense is that the confirming acts gave him that property, and Van Horn needs to go to a different part of the state. Van Horn's response sets up the constitutional issue, which is that he argues that the confirming act is itself unconstitutional there's several reasons, one of them being it's unconstitutional under the 1776 Declarations of Rights. And so the fundamental question before the court, and this is a narrowed version of it, but I think that it will really draw out many of the things that the panelists have talked about today, is not whether Van Horn has a meritorious takings claim or some other claim, it's whether the court even has the authority to invalidate this statute, whether the 1776 Constitution even gives them the authority to do that. And now I'm going to introduce the judges and the advocates for the case. First, we have Justice G. Barry Anderson, sitting in the middle here. Justice Anderson recently retired from the Minnesota Supreme Court after nearly 20 years of distinguished judicial service. He's a graduate of the University of Minnesota Law School. Justice Anderson spent the first chapter of his career as a civil trial attorney and a city attorney in Hutchinson, Minnesota. He joined the Minnesota Court of Appeals in 1998 and was appointed to the Supreme Court in 2004, where he served until his retirement in May of last year. And away from the bench, Justice Anderson has been a frequent contributor to programming about judicial ethics and professional responsibility, constitutional law, including things touching on state constitutional law. We're very grateful to have him, and for our panel, he will be serving fittingly as the Chief Justice of the Pennsylvania Supreme Court.
I always wanted to be Chief Justice, so this is good.
You'll have a little bit more than a half an hour to... Our second judge is Professor Laurent Sacharoff of the University of Denver Sturm College of Law, where he's the Maxine Kurtz Faculty Research Scholar. A Princeton graduate and Columbia Law School alumnus, Professor Sacharoff clerked in the Southern District of New York before practicing at Sullivan and Cromwell, and then as a public defender at the Legal Aid Society in Brooklyn. He brought that practical background into the academy, most recently at the University of Arkansas, where he was named Outstanding Professor of the Year before joining the Denver faculty. His scholarship on the history of the Fourth and Fifth Amendments has appeared in the Stanford Law Review, the University of Chicago Law Review, and many others, and he has been cited regularly by the courts. We are particularly pleased to have him on this panel given his deep expertise in these questions, including in the 1776 Pennsylvania Constitutions. So Professor Sacharoff, thank you. And then our third judge is Professor Cate Stetson of the University of Virginia School of Law, where she teaches appellate practice and evidence and co-instructs the Appellate Litigation Clinic. Professor Stetson is a graduate of UVA Law. She clerked for the U.S. District Court for the District of Columbia and on the D.C. Circuit before joining Hogan Lovells, where she spent 28 years as an associate partner and co-head of the firm's appellate practice. And in that time, this is a crazy number to me. Professor Stetson has argued more than 130 appeals across every federal circuit and 10 appellate courts and argued 4 cases before the United States Supreme Court. Most recently, Smith & Wesson versus Mexico, which was a fantastic argument. She's a member of the American Law Institute and brings to this panel a very good eye for high-quality appellate litigation. And then certainly last but not least are my colleagues. So first, my colleague Diana Simpson, who will be counsel for the plaintiff, which is Van Horn, the guy who does not want to get moved to a different part of Pennsylvania. Diana is a senior attorney at the Institute for Justice. Diana grew up in Colorado. She earned her undergraduate degree in economics and international affairs from Sweetbriar College and received her law degree from Roger Williams University School of Law. She came to IJ through a constitutional law fellowship in the firm's Arizona office and has been at our headquarters since 2013. Her practice focuses on property rights, zoning abuse, excessive fines and fees, including serving as lead counsel in a case that's near and dear to my heart, a challenge to Chicago's vehicle impound system. We're very happy to have Diana arguing. Then my colleague Sam Gedge will be the counsel for defendant. Sam is also a senior attorney at the Institute for Justice. Sam graduated from Harvard Law School and clerked for Judge Raymond Grunder on the U.S. Court of Appeals for the Eighth Circuit. He joined IJ in 2015 and has since built a practice centered on civil forfeiture, economic liberty, property rights, and free speech. And in 2017, he was named IJ's Elfie Galoon Fellow for Freedom and the Constitution, which is a fellowship dedicated to scholarship and public education about constitutional rights. We are very glad to have both of you arguing before the court today. And with that, I will hand it off to the Chief Justice.
We will call the matter of Van Horn's lessee versus Dorrance. Counsel Simpson, you will be speaking on behalf of the plaintiff here. Have you elected to reserve some time for rebuttal? 2 minutes reserved for rebuttal. The floor is yours. You may begin when ready.
Thank you, Mr. Chief Justice, and may it please the court. Pennsylvania broke away from a despotic regime to form a land of free men, united by consent and led by a government that is devoted to protecting their natural rights. So central was the notion of preserving natural rights to the authors of the 1776 Constitution that they placed the Declaration of Rights at the very beginning, before vesting any power in any branch of government. Among those enumerated rights is possessing and protecting property. Under the 1776 Constitution, it is Pennsylvania's obligation to respect Van Horn's property rights, and in the face of a failure, it is this court's duty to enforce that document. The role of this court is to resolve legal disputes, including this very one. This court is the head of the judicial branch of the government that was established by the 1776 Constitution. Sections 23 through 30 of that Constitution discuss the powers and the limitations of the judicial branch.
Simpson, can I ask you, there is, of course, another body that is empowered with the ability to resolve constitutional disputes, the Council of Censors. Where do you see their power ending and ours beginning?
Your Honor, I don't see them as conflicting in any way. There is nothing in the Constitution that says that the Council is the exclusive mechanism to address the constitutionality of laws. Indeed, both the Council of Censors and this court can address the constitutionality of various laws in various factual circumstances. And so the founders cared very much about the rights of the people, and this was their guiding light, and they created the Council of Censors to establish a backdrop of judicial review, a two-pronged approach to ensure that the laws binding Pennsylvanians were constitutional. And so one track emerges where a particular person feels themselves subjected to an unconstitutional law and they file suit seeking review. And then this other track is the Council of Censors, who convenes to determine whether the Constitution was being followed.
Point me to where in the Constitution those two tracks are specified.
So the Council of Censors, Your Honor, appears in kind of some of the later sections of the Constitution, and then sections 23 through 30 talk about the judicial branch. Both of them do appear in that text. And if you look at, I think an example might be helpful here. And so if you look at Section 29, that section prohibits excessive bail and fines. And the Crown's abuses of its subjects were notorious. And Judge Jeffries was a particularly notorious example of this. And he imposed a 10,000-pound fine on Sir Samuel Barnardston for writing seditious letters. And Sir Barnardston was unable to pay this sum, which was an egregious amount, and it still is today in 1795, and he languished in prison while his estate was ruined. And so even Judge Jeffries, in imposing this fine, had to evade Magna Carta's limitations on amercements to impose that fine. And so assume that this fine were presented to this court by Sir Barnardston, and that this court would declare unconstitutionally excessive that fine, which I think it certainly would. There's legal and historical reasons to do so. But that's not the end of the story. Imagine that the next time the Council of Censors gets together, they review this penalty that had been imposed on Sir Barnardston, and they decided to take it a step further. They censured or otherwise sought impeachment of the prosecutor. They recommended to the legislature that fines be capped at a much lower amount than $10,000, or even that prohibiting sedition is unconstitutional, whether it violates free speech or other protections given in the Declaration of Rights. So not only would Sir Barnardston be protected in such a situation by his...
But the Council of Censors can't void a law. It can only recommend to the legislature that it repeal the law. Isn't that right?
Yes, Your Honor.
But you're asking us to void the law. Isn't that right?
Yes, Your Honor.
So you're asking us to exercise more power than the Council of Censors during the time period in which they existed had. And so I understand what you're saying about two tracks, but it seems like the judicial track swallows the censor track, because if the censors are limited to not voiding laws, you would think that the judiciary should be limited from voiding laws.
Your Honor, I think because they do different things, right? And so in Sir Barnardston's example, the judiciary would strike it down as unconstitutional as applied to him in his particular circumstance.
But let's talk about this because it's a law, not a
Sure.
executive official acting. You're asking us to void a legislative law. That's a big difference. And the Council of Censors did not have that power. And so it seems reasonable to infer that the Constitution was following a strong legislative supremacy principle, for example, unicameralism, and it's much more legislative forward than other constitutions, including the recent federal constitution. So given that strong legislative bias, and the fact that the Council of Censors can't void a law, I read that to mean that even if the judiciary track coexisted with the Council of Censors, I don't see the judiciary having more power than the Council of Censors, which is set up precisely to deal with unconstitutional legislation.
Your Honor, I think most can agree that the 1776 Constitution was a good first try, and that the founders then, in drafting the 1790 Constitution, learned from some of their mistakes. And one of the things we all saw with the Council of Censors was that it didn't actually work, right? That it was immediately paralyzed by this political environment, and that no one could agree on anything. And so,
Counsel, I want to back up here a little bit, and I just want to make clear that I understand what the issues are. Is it my understanding, or is my understanding correct, that you need to have this court find the statute here unconstitutional? That's the relief you're asking for. Is that correct?
yes, Your Honor.
So if we conclude that either we don't have the authority to conduct judicial review, or for some other reason that the statute is constitutional, then your client would not prevail.
Yes, Your Honor. I need to win on both elements, and I think we do, because the Constitution is supreme law. It binds the legislature, and the judiciary's role is to enforce that. And so Section 9 does grant the legislature broad powers, as you were saying a moment ago, Your Honor, but it limits that. It says they shall have no power to add to, alter, abolish, or infringe any part of this Constitution. And we saw concerns throughout the Constitution, throughout the founders, throughout writings at the time.
I'm still upset about this. Why wasn't the Council of Censors given the power to void an unconstitutional law?
Because it existed as a separate type of body, Your Honor.
Sure, but I mean, if it was created to monitor the legislature from creating unconstitutional laws, it expressly says that, you'd think that if voiding laws was one of the remedies that should be available to anyone monitoring the legislature, the Council of Censors would have that power. The fact that the legislature did not give them the power to void a law, only to recommend that the legislature repeal it, suggests that the writers of the 1776 Constitution did not want anyone to just void laws.
If the founders so limited the judiciary, they would have said so directly, and they never said so directly, Your Honor. And Madison warned about this exact problem in Federalist Number 48. He talks about parchment barriers, these declarations of rights that are enforced only by political mechanisms, and that they are inadequate to restrain legislative overreach. I think our founders fully understood the failure of man in leading other people, and that in setting up governments, you have to establish checks and balances, and that's what they have done.
Follow up on my brother Justice's question. If you have two separate bodies, one of which is judicial, the other which is something that is not, one of them has the power to veto a statute, the other does not, who is going to pursue a remedy under that separate entity that looks like it was established exactly for this purpose?
Your Honor, I don't think that the Council of Censors was ever designed to be responsive to a particular person's challenge in the way that the judiciary is. And so we're here, Van Horn and his lessee are here today because the judiciary is designed to hear individual cases.
So the council is just a roving commission of unconstitutionality spotters?
Yes, Your Honor, I think so. And I think that was, which is why it was a good idea perhaps on paper, but then it just didn't pan out, right? The idea of having the ability to go after a situation and say, you know, not only is Sir Barnardston going to be able to prevail in his direct challenge, but then you have a group of people sitting back with cooler heads saying, okay, well, how did this happen here, and how can we prevent this from happening again? And so you have broader constitutional protections than exists with just narrow rulings on behalf of one or two people. And so the Declaration of Rights is a critically important part of the 1776 Constitution. The presence of the word ought in it doesn't make it any less than. This is an operative provision that integrates the Declaration into the Constitution.
Why is this, okay, on another issue, why is it even unconstitutional? For example, people are given an equal amount of land, and so what's wrong with that?
Your Honor, because it takes Van Horn's vested property, this is property he owned appropriately, and it takes it from him and gives it to a man from Connecticut without consent or compensation.
Well, okay, so the consent part is weird because if you read the provision and poor Connecticut, but I think we can all agree, if you read the provision literally, unlike the federal Constitution, which allows for taking with compensation, with money compensation, the Pennsylvania Constitution doesn't even allow that. Like, if a person says no, the government can't take it even if they pay them and even if they give them a jury trial, they can't do it. Is that your reading of it?
Yes.
Okay. So even the the Fifth Amendment to the recent federal Constitution would be unconstitutional under the Pennsylvania provision.
Because the Pennsylvania Constitution was designed to be a bulwark of constitutional rights and natural rights.
Okay.
And Your Honor, I see I'm running low on my time. I would like to reserve my remainder for rebuttal, if I could, please.
You may do so.
Thank you.
Thank you, counsel. Counsel Gedge, the floor is yours. You have 15 minutes.
Thank you, Mr. Chief Justice, and may it please the court. My friend and I share common ground that the 1776 Constitution limited the power of the legislature, but so too it limited the power of the courts. And in its text, its history, and its structure, the Constitution confirms that the people did not delegate to courts the power to void statutes enacted by the people's chosen representatives. Textually, Section 24 of the Constitution delegates to this court and to the lower courts, quote, the powers usually exercised by such courts. And so as a historical matter, the question becomes, in 1776, did the powers usually exercised by such courts include the power to void duly enacted statutes? And the answer is no. Blackstone himself said that the answer is no. That is not a power usually exercised by the courts. And in turn, it's not a power delegated to the courts by the text of Section 24. Now, that conclusion is reinforced by the Constitution structure. Had the framers wanted to vest the courts with the conspicuously unusual power to void statutes, they would have said so. But instead, they delegated a similar type of authority to a different body entirely, the Council of Censors.
Just to ask you about that, Mr. Gedge, you know, as I'm sure you're aware, the Council of Censors met precisely once. The Council of Censors was so dysfunctional that it makes, you know, a reality show episode look odd, if that were a thing in 1790. How is it a logical and reasonable reading of this document to suggest that the ability to challenge a statute would rest with these, you know, 25-odd dysfunctional individuals?
So 2 points, Justice Stetson. I mean, I think historically that's not entirely a fair characterization of the Council of Censors. They had their problems, but in fact, they recommended repeals of a number of constitutionally suspect pieces of legislation. And in the following session, the legislature took those recommendations seriously and repealed the suspect legislation. So in that regard, I think the system worked.
But they only met once every 7 years and could only act during that 1 year. So in addition to my colleagues' complaints about the practice, the way it's set up seems to be 6 years out of 7. The legislature can pass unconstitutional laws 6 years out of 7, and they won't be reviewed until the 7th year. Isn't that right?
So yes, although I think I'd resist the premise that the legislature would be passing unconstitutional laws, because ultimately the question, well, because I think,
Indulge us.
so you know, my point isn't to kind of resist the premise that in theory there can be unconstitutional laws, but rather under the 1776 Constitution, the entire premise was that the legislature itself would be the last word on whether its laws were constitutional under any form of government.
But can't the judiciary step in during year 2 through 7 when the Council of Censors isn't sitting? It seems reasonable for the judiciary to do what it always does, which is kind of stopgap stuff. And so it can, you know, maybe not void it exactly, but, or maybe void it, but it seems like during that interregnum when there's no Council of Censors, it makes sense for the judiciary to perform that role.
So it might make sense, Justice Sacharoff, but the problem is that's not what the 1776 Constitution does. And you know, I'll note that, of course, there may well have been problems with the Council of Censors, but my point more fundamentally—
But then why have that 6-year gap? Like, it seems like they must have thought, well, the Council of Censors is for super-duper problems. And the judiciary, I mean, I don't know which category this fits under, but, you know, if there's something that's unconstitutional but not, like, a big deal, maybe the judiciary can step in during the intermediate time, because it just seems weird to have this long gap.
Yeah, I mean, it may be weird. I mean, I think the easy answer is that's how they wrote it, and if we don't like it, well, we can amend the Constitution, which we did. But I think more fundamentally, what it shows is that the framers were very serious about the idea of legislative preeminence, and they wanted to entrust the legislature.
I want to go back to sort of the fundamental question that I raised with opposing counsel, and two-part question. Are you arguing here that that there is no that there's no authority or power to declare a statute unconstitutional? Or are you saying this court could find a statute unconstitutional, but this one isn't?
Well, both. I think the question presented to this court today is the former, though, Mr. Chief Justice. And I think at base, my friend's argument boils down to the idea that the judicial branch is a coordinate, co-equal branch of government, and the Pennsylvania Constitution is the supreme law of the land. So, of course, the court should have the power to void it if there's a conflict between the Constitution and a statute. I think my friend used the phrase, you know, this court is the head of the judicial branch. And I think the fundamental problem with that premise is that this court, under the 1776 Constitution, wasn't a coordinate branch of government.
So are you acknowledging that we do have the authority, or are you disputing that authority?
I am very much disputing it, Mr. Chief Justice.
Do we have it now? If the statute were passed yesterday, could we void it?
I think it would
under
be
the current Constitution.
Right. I think that would be a much closer question, Justice Sacharoff. But of course, we're under this 1776 Constitution.
Well, are we?
Yes.
Why?
Because that is the question presented that this court granted review on.
Well, no, I mean, we are and we aren't. Like, we're under it in a sense, but one question presented, the court can always deviate from that. But two...
We do it all the time.
Yeah, exactly. I mean, like, there's this kind of timing issue as to, we can interpret the Constitution back then, or we can, take the view, like the Supreme Courts often make rulings that are retroactive in the sense that thus the law always was, and we're only discovering the law, we're not creating it. And so if we think we have the power to find a law, especially since the Council of Censors has been eliminated. So once the Council of Censors is eliminated, but it's a law before 1790, there's another gap where maybe we need to use our current judicial review powers, even if it's a law before 1790.
So I would urge the court against that kind of radical shift in how the case has been presented to it, not least because the fact that we're talking about the 1776 Constitution here potentially limits the knock-on effects of a ruling, really on either side, but certainly in favor of Mr. Dorrance. I mean, ultimately, if the court, for want of a better phrase, is winging it under the 1790 Constitution, that will have serious effects going forward. But of course, as the case comes to the court, we're talking about the 1776 Constitution. And back to my response to you, Justice Stetson, ultimately, the conceit of the 1776 Constitution was that the legislature was preeminent. It was preeminent over the executive branch, and it was preeminent over the courts.
Not preeminent in at least one respect, right? Because Article 11 of the 1776 Constitution specifies that property disputes shall be subject to trial by jury, and that right shall be sacred. So when you have that jury trial right enshrined in this Constitution, how do you then say that there is no judicial review of a right that goes directly to a property interest?
Yeah, so I think that raises two separate questions. One, does that provision bind the legislature? And we wouldn't dispute that it does. They're obviously subject to requirements saying they can't violate the Constitution. But the question presented here is a second-order question, whether this court has the power to disregard statutes that are duly enacted by the legislature. And the answer to that is no, even if this court thinks that a particular statute is, in conflict with the Constitution.
Would you agree this is a controversy respecting property?
This lawsuit is, and Mr. Van Horn has access to the courts, as we can tell, because we're in a court. I would not concede that the enactment of the confirming statute in 1787 amounted to a controversy concerning property. But I will spot you that for present purposes, because I think ultimately the question here is, can a court disregard a duly enacted statute because they think it conflicts with the U.S. Constitution? And not the 1776 Constitution. And the answer to that, I think, is no, because the courts lack the power themselves under the 1776 Constitution to exercise that kind of authority.
One of the things you said courts do have the power to do is to do what courts normally do. And so I want to talk about some other rights that are more within the realm of what courts do, and those would be like negative or defensive rights. So if a defendant in a criminal case has the right to a jury, and if the legislature took that away, but the court is obviously overseeing the trial, does the court have the right to ignore the law and conduct the trial, according to common law, or whatever theory they use, afford the defendant a jury because the Constitution requires it? How about that scenario?
So, no. Assuming, as I think your question does, that there is a statute passed by the people's representative saying folks in this situation don't get a jury, no, because it's one thing to say that a legislative statute violates the Constitution, and it's something fundamentally different to say, and the courts get the last word on whether a duly enacted statute violates the Constitution.
Well, they're not, it's not like they're declaring it for all the world, although it may have that effect. It's a single case in front of them. And what courts do is impanel juries and try cases. So that seems like, if I were a judge, I'd be like, sure, the legislature can say there's no jury. I'm going to run my courtroom the way I want to, because this other section of the Constitution says, I can do judge stuff. It's clearly judge stuff. And impaneling a jury for a criminal case seems like, I'm not saying that now I'm the trial judge, I'm not saying that the Pennsylvania legislature's law is unconstitutional. I'm just ignoring it.
And I think that's the precise problem, because under the 1776 Constitution, the courts were deliberately subordinated to the legislature. And by ignoring a statute, even if only in one case, the courts are breaching the limits on their power, certainly under Section 24
but they both,
of the Constitution.
But you're saying the legislature's is preeminent, but I don't have the provision right here, but it was cited by your opposing counsel that judges have or I think you cited it. Which provision is it that says judges get to do their judge stuff?
That's right. Section 24 says that they have the...
A very technical term.
Yeah, exactly.
But that's exactly right, Justice Sacharoff.
Besides the powers usually exercised by such courts, impaneling a jury in a criminal case seems like it falls within the core of Section 24.
But not when doing so requires the judge to disregard a statute.
Okay, where is that coming from?
That is coming from the entire concept of the 1776 Constitution, and more fundamentally, the backdrop against which the 1776 Constitution was enacted. So,
Just so I can understand as I'm editing this Constitution, it's the powers usually exercised by such courts, except when the legislature says that the courts can't exercise those usual powers?
No, not at all, Justice Stetson. Because the powers usually exercised by such courts in the years and centuries leading up to 1776 encompass the power to apply statutes passed by the legislature, their parliament. Their power did not include the authority to second-guess enactments of parliament, even if they thought it conflicted with some kind of higher charter. And so that's why I say that under Section 24, the courts don't have the power to second-guess.
Another power the courts have is if they're presented with two conflicting statutes. Let's say one statute says you have a jury right, and one statute says you don't. The court would have to decide which one is preeminent. Let's say one came after the other, then they would say, well, the second one is preeminent. That's a judge thing, right?
That is a judge thing,
Okay.
Your Honor.
So let's say that there's one statute and one constitutional provision, and those also conflict. And isn't it a normal judge activity to say, well, I have a statute that says no jury trial. I have a constitutional provision that says jury trial. Those conflict. I've got to decide which one is controlling. That's not like voiding the legislature exactly. It's doing a judge thing, which is deciding what the law is.
Well, I'll note parenthetically, Justice Sacharoff, that my friend conceded that they are, in fact, asking this court to void the Confirming Act. But to kind of take your question...
Right. That's why I brought up these more negative defensive rights, because then I was hoping you would concede that, and then I could go to affirmative rights, but you didn't concede that, so I'm still trying to get to that point.
Because I think it is a bright line rule, and certainly we can envision a constitution that has some kind of Montesquieuian three parts of government with each trying to be a check on the other. Maybe that's a good idea, but that is not the Constitution.
No, it's not the check. It's like you have two sources of law, they conflict. Judges have to decide which one applies. How is it possible that the constitutional one isn't the one that applies when you're just picking which lane you have to go down, and how is that not a judge function?
Because under the 1776 Constitution, the governmental body with the final word on whether a statute is constitutional is the legislature. And by enacting the statute, they have announced the final word on whether that statute is constitutional. They are not subject to a check by the judiciary. The judicial branch wasn't even a thing under the 1776 Constitution. They are, however, subject to many other meaningful checks at the hands of the people themselves, right? There's annual elections. Any bill is only provisional until the next session. There's, of course, the Council of Censors, which we can quibble with its efficacy, but it was clear, I think the most important teaching from the Council of Censors provision is that the framers thought long and hard about how are we going to handle a situation when a piece of legislation arguably conflicts with the Constitution, and they set up a textually explicit grant to a body accountable to the people. They created a highly reticulated regime, and I think it would have been passing strange for them to have gone to those lengths if they had meant for an even greater power to rest in the hands of every judge, high and low, across the Commonwealth of Pennsylvania. I see my time has expired, but if the court has any other questions, I'm happy to answer them.
Thank you, counsel.
Thank you.
Your time is concluded. Counsel, you have 2 minutes for rebuttal.
Thank you, Your Honors. Just a few quick points. My friend on the other side said that that other states don't exercise this right. And with all due respect to him and to Blackstone, that's just not right. New Hampshire, for instance, has been exercising judicial review. And so to say that that this court is supposed to do things that normal courts do, well, that's one of them. Government exists. And
Well, you would agree, though, that it's a disputed right. I mean, there certainly have been policy arguments about the wisdom of judicial review. Brutus, other places, the dangers of fully independent legislature. Those are real things, right?
Certainly. And the point I wish to make with that is that it's not as though this court would be the first one going into the woods, having never been there before, having nobody ever been there before. There are courts engaging in judicial review, and that is what this court should be doing as well. Government exists able to exercise the powers given to it, only with the authority granted to it from the Constitution. And so when it's acting beyond the scope of that, it's acting ultra vires, and these acts are void from the beginning because the legislature never had the power to enact them in the first place. And it is this court's role to do that. And this court already exists to resolve.
Suppose two plaintiffs, one goes to court and one goes to the Council of Censors, and each comes to a contradictory conclusion.
This court would take precedence, Your Honor, because this court has the supreme judicial power of the state of Pennsylvania.
So if the Council of Censors, I'm trying to see which direction it would have to go in, but like the Council of Censors, well, I mean, they can't void a law, so they can only recommend repeal, but they can impeach people. So suppose the Council of Censors impeach, I mean, I guess it could coexist, impeached the legislators who passed it, but the judiciary said it was constitutional. I mean, I guess that's fine.
Maybe they'd, yes, maybe they'd have a duel. I don't know exactly
Right.
how that would resolve. And you know, and amending the Constitution is an opportunity, and that is what the founders of this country have done, or founders of the state have done. And they did that with the 1790 Constitution, and it has, I think, some challenges, and I don't think it was a perfect document in 1776. I don't think it's a perfect document in 1790. But what this court does is resolve legal disputes and debate between conflicting statutes and conflicting interpretations, and doing that with regard to acts and the Constitution is just another version of judicial review.
If this provision gave a right to jury, would it be constitutional?
Yes, Your Honor. I mean, the Constitution.
But it was a land swap and not a cash payout.
Oh, I see. So you're saying if the Confirming Act had a jury.
Yeah, I mean, I think you're arguing it's unconstitutional for a few reasons. I'm wondering if you fix the jury part. I mean, I know you already said it has to be with consent, so I guess everything is unconstitutional. Every effort would be to fix this problem would be unconstitutional.
I think every effort that resolves with Van Horn walking away without his property and without payment is unconstitutional.
Well, without payment, but if he doesn't give consent, even payment isn't enough. It just says consent, and if he doesn't consent, you can't take it away with fair payment and with a jury.
My apologies, Your Honor. I was toiling under the Fifth Amendment, not the 17th.
Well, exactly. Like the Fifth Amendment, which was, recently passed, seems like a sensible middle ground, and the Pennsylvania Constitution, it just seemed...
We are dealing in sensible middle ground here.
I know it's a bunch of radicals, but so no matter what the emergency, the government can't take someone's property no matter what.
So I think that
it.
is a fair reading of the text, Your Honor. But if this court doesn't wish to address that question, I think the primary question presented is whether judicial review exists and whether the judiciary can address constitutional issues. So this court could answer that first question and then remand for further proceedings for the lower courts.
For lower courts to
figure it
decide
out.
whether the legislature passed an unconstitutional law?
Yes.
Right.
Accordingly, we'd request that this court declare that judicial review exists and perhaps remand for further consideration. Thank you.
Thank you, counsel. The matter is...
Please give a hearty round of applause, another round of applause for our judges and our advocates. That was excellent. And now I think it's time for
So we will announce our decision seriatim. We'll begin with, let's begin with Justice Stetson. Justice, what's your view on the enlightening argument we just completed?
I want first to commend both of the advocates. Am I still Justice Stetson, or can I just be?
Yeah, we're unofficial now.
Okay,
so
good.
Yes.
This wig is super itchy, so I just want to. I just want to commend both of you that those were absolutely superb arguments, both in terms of your delivery and the substance of what you knew, the depth of what you knew, and how you were able to convey it. It's just marvelous. I have concluded that Ms. Simpson has the better of this argument. And I have concluded it for a relatively simple reason, which is that I think Mr. Gedge's argument is bananas. I do not see how it is legally or practically possible for a council of censors to meet once every 7 years, as my brother Justice said, in order to pass general judgment on the state of things in Pennsylvania. I think that the Constitution as written and the provision for property rights to be adjudicated before courts necessarily bespeaks that the judges are to have some review capability, including when it comes to deciding issues of the constitutionality of a statute. So I would rule in favor of Ms. Simpson.
Justice Sacharoff?
I will go the other way and be bananas. Won't be the first time. I don't believe there is judicial review because of the Council of Censors. That's the mechanism. I mean, it was the framers of 1776 Constitution were radicals. They had a unicameral legislature. Like, they were so into legislative supremacy as the representatives of the people, with the only check being Council of Censors, and even they couldn't avoid the law. So I would say that the court then certainly, and I guess now, does not have the power to invalidate a statute in this context. I think maybe my hypo, they might.
Well, we're divided 1-1. I have a conflict. I'll be leaving. No, I'm going to agree with Justice Stetson. I think that there is there is an implied right of judicial review here, although the argument that Justice Sacharoff makes has a lot of merit to it. Anything associated with Thomas Paine is probably by definition bananas. He did one great thing. He wrote Common Sense, and otherwise has been.
It's not common sense.
Yeah, this is not about common sense. It's a really interesting question, this issue about the existence of judicial review. And the materials that we were given, and I think you have as well, you've got Federalist 48 and 68 that talk about the dangers of judicial review, yet Federalist 68 seems to say that there's a sort of an underlying presupposition that judicial review exists. It's a little difficult in this context, as Justice Sacharoff points out, because of the radical nature of the Constitution. But what you don't have, at least I wasn't able to find, is any flat prohibition. There shall not be any judicial review. And on that thin reed, I am going to, that negative implication, I'm going to agree with my colleague Justice Stetson, and henceforth all the blog posts and whatnot can complain about lawless judges. But anyway, that's where we're at. Thank you all very much.
Thank you.
Yeah.
Thank you again to our judges and advocates. I'm not sure that we have time for maybe a couple questions before the reception. Great. So if you have a question, why not? Otherwise, we're going to go across the hall. There we go. Josh.
I have a question for the advocates.
Yeah, there you go. We approve.
How long did it take to prepare? Because I can tell you this, it would have taken me a long time to do that.
Incidentally, one of the things we should do here is we should thank the author of the problem, who's standing right over there.
Yeah.
I have to say that when I got this, I did not know that there was this earlier Constitution. I did not know that Thomas Paine, in addition to messing up the French Revolution, was messing up the state of Pennsylvania. So,
Thank you.
question?
Well, first, as an aspiring IJ attorney, I thought you guys didn't bill hours. Kind of prompted by Justice Sacharoff's point, if the Council of Censors had greater power to not just recommend that something be repealed by the legislature, would you end up with a situation where you have 6 years of unconstitutional rule by the Pennsylvania legislature and then a year of jubilee in which the people are freed by the Council of Censors?
Yeah, I mean, that's how I read it. Like,
It's almost biblical.
It is very biblical every 7 years, and yeah, absolutely.
Hi. So this is working. Yeah. This may be a question. It may be a confession, but I found it quite possible to follow the time period, to hold myself in the time period mentally when the lawyers were speaking, and I found it much more difficult when you guys were questioning. And I wonder whether, for instance, Judge Sacharoff, when you said now, were you talking about now? Do you remember you asked the question about if this legislation were passed?
Oh,
think
yeah,
you
I
said
meant
yesterday or
1795,
today or
as
something.
opposed to
Were you talking about in our time frame or the time frame at which this panel is in theory sitting?
when the panel was sitting, as opposed, like 1795 versus pre-1790.
Got it.
Because it was two different constitutions.
So, but when you also spoke of negative and affirmative rights, and that language would have been completely anachronistic in the time frame of the sitting, right?
Yes, you got me.
And so
The winner of the Careful Listener Award.
I mean,
Applaud, yes.
that was the illustration
I was reading some of my questions off of this, Looking Glass.
I was thinking, how does this apply today? And then, no, they're applying it at this time, but then some of this has to apply to the period prior to the time in which they're sitting. And so I found that fascinating and baffling.
Yeah, the dead giveaway was the reference to the Artemis moon mission, but yeah, it's... All right.
Yes, so thank you one more time. Thank you, the judges and advocates. And we will be, sorry? The outcome was that there is judicial review, in fact, under the very strange 1776 Pennsylvania Constitution. It was a vote of 2-1. I'm sure a dissenting opinion will follow. Mm-hmm. Yes. We will have the reception at 4 across the hallway, so we'll see you there. Thank you, everyone. Oh, it's ready. Perfect. Thank you.